Gentleman yields back. The gentleman, Mr. Casten, is recognized for 5 minutes.
Thank you, Mr. Chair. Thanks to all for being here. So I remember when I got out of college, I was living in Boston when I was in my 20s, mostly just reading the Federalist Papers. But I remember there was this great pizza restaurant over on Commonwealth Avenue by BU that rather famously the pizza was fantastic, to be clear. They were found to have basically retained virtually every law firm in Boston, and they would hire young lawyers to go make deposits at banks that were often just below the levels that would trigger AML requirements, but if they were above, the FBI office was full of pictures of young aspiring lawyers whose firms had all been completely conflicted out of ever working against the owners of said pizza restaurant. Nobody would have ever argued that the beneficial use case for this particular pizza restaurant meant that we should never regulate pizza restaurants under AML protocols. And I get concerned in this DeFi conversation that we're framing this as it's beneficial use. It's really good. It's maybe as good as the pizza that was at this pizza joint. And therefore, we shouldn't have anti-money laundering rules. Like, that doesn't make any sense to me. Mr. Hayes, you'd mentioned the UkiDAO case where my understanding is that UkiDAO was actually advertising that that you could get around AML laws, and CFTC has come after them, had alleged that they were actually created with the explicit goal of operating an illegal trap form. So I guess, Mr. Van Valkenburg and Mr. Tuminelli, I'm just curious, yes or no, because I don't want to misunderstand your testimony. Is it your argument that if a DeFi protocol is found to be violating anti-money laundering rules, should there be any legal accountability to the creators, the operators, the people maintaining that service? Just yes or no. Should those people have any legal liability?
Those who are not decentralized, those who are custodial, have AML laws that apply, and they should be applied, and they should be enforced.
If it's a DeFi protocol, are you saying that we're saying it's decentralized?
An immutable smart contract that I transact with?
I'm just asking yes or no. Should they have
As
somebody wrote the code?
As an American transacting with a mutable smart contract, I'm transacting with my own funds. I should not be subject to the Bank Secrecy Act.
Okay, so you think no. Ms. Tuminelli, you think yes or no? Should there be any liability that's there?
I think bad actors should be held liable for the bad conduct that they engage in. Not the developers, not the people who created the software. It's the bad actors who actually committed the crime. We should go after them.
So there should be no liability for the people who created the tool. So back to my pizza example. The people made the pizza joint. They used these laws. There should be no liability for them because they're just pizza. They're just pizza producers.
If I make a neutral tool that somebody uses to commit crime, I should not be held responsible for that person's conduct.
Okay, Mr. Hayes, that's bizarre. I mean, that's aiding and abetting commission of a felony. Mr. Hayes, who do you think should be held liable in those cases? Is it the DAO members? Is it the creators? Is it where should that liability lie?
I think it's a good question. It's complex, but I think you can apply existing laws to find some answers. I think it also depends on the facts and circumstances of those cases. But I think what you're raising raises a conundrum. Developers and admins intervene in the platforms that facilitate these transactions on a fairly regular basis, either directly or indirectly through the functions of the DAO. They update the code, they issue assets, they help determine how the validation process works. There are many times when interventions happen by individuals with knowledge. Those include people outside of the developer team and inside the developer team. And it's tricky because why are they intervening in those moments when not only are those about the infrastructural operation of the platform, but actually what the platform does, which is to facilitate transactions and move assets. Why then should they not be held accountable if the transactions that they help facilitate end up facilitating illicit finance? So I would argue that you have to find a way to hold developers accountable to some degree, and the question is, where do you draw that line?
Okay, so I want to get back, because I think we talk about this technology as being unique and not recognize that we have, to your point, we have these tools. If I buy a security on NASDAQ, I have to disclose, and NASDAQ has clearing offices and they verify the identity, and I guess, Ms. Rettig, coming to you, following on your exchange with Mr. Foster, in the case of a NASDAQ transaction, there is a clear custody title that is clear. There is no way to participate in that as an anonymous actor. Is there any reason why we could not insist on those rules for DeFi protocols? And if you want to be anonymous, if you want to think you can duck rules, fine, you can't play in the sandbox.
I think it goes to what Mr. Van Valkenburg talked about in his oral testimony, which would be importing intermediaries into disintermediated systems, which will put the U.S. at a large-scale disadvantage from a long-term perspective.
Look, I'm out of time, but there is no disadvantage to the U.S. economy of not protecting the interests of child traffickers, money launderers, and the North Korean nuclear system.
The one point on your pizza example is that the pizza restaurant had individuals who were acting with scienter, and that's very different than
Gentleman's
what's going on
time
here.
has expired.
Yield back.